information that comes in, you request the court for a permission to amend your complaint or amend your action, and you explain why, and right along with your request you put exactly what you want to say. Okay, you have the actual paper, and then they will either say yay or nay. So you have the request, but then you have the actual paper you're requesting to be allowed filed.
So suffice to say that all the research and all the code research and all that needs to be done up front completely.
Absolutely, when you're at law. Okay, see, in equity proceedings, they allow you to make general complaints and provide the facts later. Now, if nobody says anything, you'll provide the facts at the trial. Okay, but what actually happens, if you have halfway decent attorneys, they'll do what's called discovery. Why is there discovery? Very simple reason. You didn't present all the facts. Now, when we're at law, we laugh at discovery. Okay? These attorneys, we throw the whole thing in. In fact, in one of our demurs, the attorney complained that we threw in all the facts too. I kind of laughed or chuckled to myself when I saw that. But the fact, and they're expecting to do discovery. Okay? Well, how can you discover something that doesn't exist? I mean, we've shown you everything. Okay? So we just ignore them. They come through with this, and we hope that they go to the court demanding discovery, demanding us to comply. You know why we hope? Because every single time they file a paper, they run their costs up. And that's the objective, one of the objectives. Okay? We don't frivolously run their costs up, but if they want to run their own costs up, hey, go for it. I love it. And because every time they put a paper in, they're charging their customer $1,500 or so. Okay? So it's great. We like it. The more the merrier. And here's what their options are. Let's say you ignore their discovery request. Now, discovery is designed to be reasonably efficient. They simply have to send you a notice. The attorney sends a notice, and that is considered a court order, even though the judge didn't sign it. And so you're expected to comply. But obviously, you have complied in advance when you provided all the evidence. They can go then to the court demanding one of two things. They can demand, A, that you produce the evidence that they're demanding, or B, that they can do what's called a motion in limine, which is to prohibit you from presenting any further evidence. Okay? If you're unwilling to disclose the evidence in advance, because the theory is everything should be out on the table as far as facts go. Now, how you interpret the facts, that's private until you get to the trial. So the interpretation, they don't have privy to. But what the facts are, they have it. There's a beautiful case in Georgia. This case, the judgment was for $5 million. It was the largest judgment by a jury in the history of Georgia at the time. I don't know, it happened back in the 60s or 70s, something like that. What it was that this truck came over this hill. There were a whole bunch of cars there stopped because of an accident. And this truck just plowed through, big semi, just throwing cars out of the way, okay? And he went through, he made a nice pathway through, and he continued on. Companion truck, same company, came through, saw the clear path, and went through too. He didn't hit anybody, but he went through. Okay? Didn't stop. So there was in the very last car of the line, there was a little girl, and she got killed in the process. Okay? So when the truck came through. The first one. Yeah, the second one didn't hit anything. His problem was he didn't stop. He should have stopped. Okay? And but anyhow, so this little girl died. So the insurance company and the defendants, because they demanded to see the evidence on discovery, and part of the evidence was a lot of film footage. So I said, sure, here it is. So they looked at it. Well, that was the evidence, yes. However, when they made their strategy, the plaintiff made his strategy, the plaintiff rearranged the film. Same stuff, but they arranged it. And they arranged it so it told a story. And the last little film strip was a whole movie showing this little girl, all dressed up pretty, saying, bye, bye-bye, bye-bye. And she died. What an impact that had on the jury. That was strategy. Okay? That's different from facts. So when you present your facts, tell a story. Tell a story that has impact, even if it's on paper. If they want to know what the facts are, at the time that you file the lawsuit, well, it's a little difficult because it's all on paper. I mean, you don't have that opportunity to rearrange unless you actually go to trial. You know, there's a big difference between strategy and facts. So be sure, if you want to win, you tell your story. Make it a good one. But you don't have to tell the other side until the critical moment. Yes.
So you said the defendant might send out a notice for discovery. Do you have to answer that?
Nah, just ignore it. They got all the facts. What's their point? They don't like it. They can always take you to court. Cost them $1,500 for each motion they make, or whatever the current price is. Sure, just ignore it. When you get to court, they're gonna say, Your Honor, we demand a discovery. We want the facts. And you're saying, what facts? Your Honor, I want an order prohibiting them from presenting any of those hidden facts. Okay. You know, because you got the whole story in your original lawsuit. Yes.
So when you file a complaint, you have to attach all your evidence or the facts along with it, or
yes, you put all your evidence, everything, 100%. There's nothing to say once you filed your lawsuit. If you have anything more to say, it's because they said something you have to, in their answer, that you have to take care of. But no, you present the whole story.
No, the story one thing, but like, you know, other evidence that to support your
No, there is no other evidence. It's all there the first time.
I mean, just the fact that you put down whatever happens, but I mean, evidence...
Which part of presenting all the evidence don't you understand?
I'm just saying, do we need
serious.
to attach any piece of...
anything, whatever. Yes. If you got something to tell, you tell it then. You're not going to get a second chance.
So you have to attach...
You have pictures, you have records, you have medical records, you have x-rays, affidavits, anything. Whatever you got, you tell the story the first time. That's what we did with Aurora's case. We put it all in there. The whole thing. The court records from the other court, whatever we were objecting to, we put it all right there. So there was nothing left to discuss. Okay? So a very important concept of the common law. That's why there's no discovery. What is there to discover? And these attorneys, you know, these attorneys all claim to be attorneys at law. That means common law. But in truth, all of them are attorneys in equity. They don't know common law. Yes, sir.
Attorneys can ask for all sorts of things.
Sure.
That may or may not be germane to what's going on. So if they ask for inside leg measurement, what's the correct response? Well,
if you deny them that, they can do two things. One of them is they can ask the court for a court order to provide that evidence, okay, which is unlikely if the evidence doesn't exist. And the second thing they can do is that they can ask the court for an order prohibiting putting that into the case. What do you care? It's not relevant, right? Let them get a motion in limine. In limine is two words, I-N and then L-I-M-I-N-I. In limine, yes, sir.
Wouldn't the sovereign, as the tribunal, make the decision on whether their request is appropriate, valid, or can
Absolutely right. If it's your court, you make the decision. Okay. Does that make sense so far? No discovery in there. Anyhow, so from step 3 on, and this applies to both sides, from step 3 on, it's either a peremptory plea or a demur. In fact, before I forget, I'll put that in there. All right. Now let's, a demur it is, a demurrer, but not a demur. 1 R. I think with one R it'd be demure. Okay. Now, let's look at the actual lawsuit. This is called the caption. Okay? Okay. So in a normal action here, where I'm assuming you're the plaintiff here, what you would do is you would put the name and address in the upper left-hand corner. This is the California style. So the phone number is optional. They definitely want the phone number, and they will almost try to order you to put a phone number on there. But the fact of the matter is that this is a slow-moving process. There's no need for a phone number. Phone numbers are for when they want to play games. They want to give you short notice on things. Okay? And we've met that issue head on in court. And the judge is always back down. Because finally what typically the judge says is, you better check your mail because, we're not responsible if you miss a call. All right? Well, there's no law that requires you to have a telephone. So, yes.
They sometimes say they said things over the phone that they didn't.
Oh, that's right. Sometimes, he says that sometimes they will claim they said something on the phone that they did not. So, yeah, I like to have things in writing. That removes all question as to who said what. Okay? So it's good not to have a phone. And then you identify your status, like you're the plaintiff or you're the attorney. Okay? Well, obviously you're not the attorney, so you'll always be the plaintiff. But that's your capacity. Because by looking at that, a person can tell, is this paper from the plaintiff, or is it from the defendant, or is it from a third party? Could be a friend of the court. Whatever. So, because there's that possibility. So you always, in the upper left-hand corner, put the identification. Now I want you to notice that the type style that we have here, this looks like it came out of a typewriter. What you're looking at is Courier. Okay? Now, the rules say that you can have Courier or Times New Roman. In other words, you can have fixed spacing, which is what this is, monospacing, or you can have proportional spacing, which is what your Times New Roman is. I grew up with a typewriter, so I like this kind of type, and this is the legal type that's been traditional. And I stay away from fancy stuff. I do not use colors. I mean, you have to assume with legal papers that it's the words that are important, not the appearance of the words. In other words, I normally do not make things bold. Everything is the same color all the way across. Maybe if it's a really important point, I might make an exception. But generally speaking, the style of the paper is very, very gray. Okay? Very little emotion. And it doesn't mean you can't put emotion into it. But I tend, because this is how attorneys write. You see, an attorney's representing somebody else. He's not emotionally involved. And these are the kind of papers that, frankly, judges like to have. They like to have attorney-written papers. So if you're talking to the enemy, you want to be able to communicate in the style that they're accustomed to. If you deviate from that style, make sure you get some profit out of it. In other words, don't look like a kook. Look like somebody, hey, that was a good thing to do at this point. Whatever it is you choose to do. Yes, sir.
What about plaintiff improper or pro se or sui juris? Or what about even possibility of putting in sovereign plaintiff?
I stay away from all those words because I don't know what they mean.
Well, sovereign.
No. Not at that point in time. Not at that point. I'm the plaintiff. What more do you need? Okay? Everybody understands plaintiff. Everything else requires interpretation or is different. The world knows plaintiff or attorney. I don't put pro se. The reason I don't put pro se is because the phrase pro se means you are representing yourself. You are your own attorney. You are not yourself, but rather representing yourself. Okay? Once you become an attorney,